Thank you, Robert. This is an enormous treat for me, obviously. And I congratulate Cass and Miller, who, when we first discussed the idea of launching this event a year and a half ago or 2 years ago, I think you probably had not much of an idea that you'd be arguing as a finalist in the Moot Court leading into this. So anyways, it's great. And the Moot Court was fascinating, and we could just spin right off of that and spend the rest of our hour talking about that. And we'll get to it, but I don't want that to preempt a lot of other interesting things to talk about. So let me just start out by quoting Justice Stevens, who said many times that learning on the job was an important part of your long tenure. So in just talking about some of the things that you learned and some of the things that you observed that changed your mind from, you were already an experienced federal judge by the time you got to the court at the age of 55, but things looked different by the end of your tenure than they had seemed at the beginning. So I wanted to give you a chance to just reflect on what some of that learning consisted of.
Well, I guess the answer to that question would be rather long, let me put it that way.
Well,
But it's true. Every judge learns on the job. Every good judge learns on the job, that is, because your comment makes me think a little bit about the confirmation process. And when I went through the process, Ed Levy, who was the Attorney General, didn't give me any advice on how to answer questions, and neither did anyone else in the
it was a simpler age.
the White House. And I remember talking to him about it some years later when we were just talking about the apparently detailed preparation that some nominees for office, such as the Attorney General or members of the court, were getting. And I mentioned him, well, you didn't give me any help, and what's different? And he said, well, he thought that a person who was nominated for the job ought to be able to answer the questions that are raised. And it occurred to me then, and it's occurred to me many times since, that really the nominee should not be prepared to answer all the questions that are answered, because the right answer is, I've got to wait to read the briefs and think about the issues before I tell you what my answer would be. And the notion that you should in advance understand what the nominee is going to, how nominee is going to vote on cases and decide them is really exactly the opposite of the kind of nominee that you want. You want a nominee who will not come in with a predetermined agenda, but rather try to decide cases as they arise. As Byron White said many times, you learn about the case and then decide what to do. You don't have all the answers beforehand.
You made a comment in your very interesting memoir, Five Chiefs, which I'm sure everybody here has read. You talked about the Harmelin case in 1991, which was a case in which a life sentence was meted out to a first-time offender, rather minor drug offense, and the court, by a vote of 5-4, upheld the life sentence against an Eighth Amendment challenge. And what you wrote in the book, and you had earlier said in a speech that you gave, your comment was that the three justices who made up the core of the five who voted to uphold the sentence were rather new on the court.
Yes,
and that the justices that they replaced, Justice Powell, Justice Stewart, Justice Brennan, certainly would have voted the other way. And what I want to quote is the way you put this, because it's a rather provocative way to put it. You said, just as the meaning of the Eighth Amendment itself responds to evolving standards of decency in a maturing society, so also may the views of individual justices become more civilized after 20 years of service on the court. I want to give you a chance to expand on that a little. I should mention that the three justices about whom you addressed this remark were Justice Kennedy, Justice O'Connor, and Justice Souter. And they all underwent some change on the bench in the 20 years.
It's interesting that you mention that case, because I think about that case a lot, because it's an example. I mean, there were two issues in the case. One was the basic question whether proportionality is a part of the cruel and unusual analysis, and I just think the evidence is overwhelmingly in favor of Justice Kennedy's conclusion that it was, even though his reasoning didn't go much beyond stare decisis, saying we've done it in the past. But Justice White wrote on both issues, whether proportionality is part of the analysis, and then on the question whether the particular sentence was cruel and unusual. And I didn't say as much about that, although I have thought about it since then. And I just think it's abundantly clear that under today's standards, it would be held to be impermissible. And I do think that at least Justice, well, I would think all three of the justices probably would come to a different conclusion today. Mm-hmm. I feel quite sure that Justice Kennedy would, and also that Justice Souter would. Mm-hmm. But it's out there, the precedent is still there, and it's really a very unfortunate case.
Well, and speaking of the Eighth Amendment, of course, you came on the court in January of '75 in the shadow of Furman, but with the post-Furman cases about the new death penalty statutes looming. And in the book, you expressed some regret over your vote to uphold the Texas statute.
That's correct.
And
I think the vote, and the other two cases in which we upheld the statute, I think the vote was correct. But the Texas statute was particularly unfortunate because it had this mandatory death penalty followed upon a finding of future dangerousness and I can still remember discussing the issue with my law clerk, George Rutherford, who now teaches at Virginia, and he felt strongly that I should have voted the other way, and I've often thought about that because he was dead right, and as I reflected on it, and I made it definitely was wrong on that one, I think.
I mean, I guess there was a promise implicit in the post-Furman
there was sort of an understanding among those of us who voted that way in the case that in actual operation, the Texas had given indication that they would construe the statute more narrowly than the text really opened the door for.
I mean, of course, and then toward the very end of your career in the Bays case, when you basically walked away from the death penalty, although not from the stare decisis aspect of upholding the court's precedents, that was the end of a long journey of thought about this for you.
Well, it was, and actually, it was sort of, when I still remember reading the Chief Justice Roberts' first draft in the Bays case, and it sort of sunk in on me how when you go to such lengths to be sure that the death penalty is administered in a painless fashion and not with undue suffering, you are really eliminating what many people think is the proper justification for the penalty in the first place, which is retribution, due to the defendant the same kind of harm that he did to his victims. And if you're protecting him from that kind of harm, you're really not inflicting the kind of punishment that the people who were strongly in favor of the death penalty think is the real reason to justify it. So it did hit me when that case was decided that the penalty really doesn't make much sense.
And I remember one case that you cited in your separate opinion in Bays was the recent habeas case from which you had vigorously dissented, the Utek case on jury qualification and the ability of federal courts to get back into the behavior of the state trial judge in death qualifying the jury. And that seemed to have really been almost a turning point in your own thinking about the intersection between habeas and capital punishment.
Well, there'd been a number of the jury cases because they kind of moved in that direction, but the whole process of death qualifying jurors really accomplishes the prosecutor's objective of tending to get a jury that's more prone to convict than to acquit. And I think it does load the dice against the defendants in a way that's peculiar to capital cases and really quite unfair. And it seemed to me quite inconsistent with the cross-section idea that the jury should represent a cross-section of the community. And if there happen to be people out there who are opposed to the death penalty, they still should. They're still part of the cross-section.
So was it, in your consideration of the death penalty over the 30-plus years, did you wrestle with it consciously, or was it something that just kind of grew on you as you saw the way the court was handling?
Well, you're always troubled. In every case is troublesome for all sorts of different reasons, but I wouldn't say it was a continuing struggle or anything like that. You have to take the cases as they arise and to do the best you can with each one.
Before we get into some of the other areas of the court's jurisprudence, I just want to make sure people realize how busy you've been since you retired. I read somewhere that you still read every opinion of the court that comes down?
Yes, I do, and with interest. And it's funny because when I was a law clerk, I remember when I finished my year thinking, well, I know a little bit about the court now. I'm going to read every case as they come down. And that lasted for about 3 months. But since my present position, I do have time to read the opinions, and I do read all of them and have reactions to them.
And you may have some public reactions to them. I mean, I remember in the, you said you would have voted with Justice Alito's solitary dissent in the Westboro Baptist Church case, the First Amendment case.
I really thought he got it right because there's in the slander area, the rules under the First Amendment, if the person's a public figure, you can be more robust and not as thorough and careful in criticizing him because a public figure can pretty well defend himself, and it contributes to wide open debate to have that kind of rule there. But you treat private figures differently. It didn't seem to me to make sense to treat this particular family as though they were public figures, because they were the victims of some very scurrilous attacks. According to the jury, it was deliberate infliction of emotional harm, and it doesn't seem to me that there should be a First Amendment right to engage in that kind of attack on private members of the community. I thought of it very much like the defamation cases. And I thought that Justice Alito was dead right in his appraisal of the case, and I guess I was willing to say so.
You've also spoken publicly about your views of the Affordable Care Act case as the author of the the health care case, as the author of the Raich opinion that a lot of people cite as the Commerce Clause foundation for upholding the statute.
The Raich is the marijuana case in California. Right. Well, on the interstate commerce clause issue, I mean, Lickard against Filburn and the marijuana case, it seems to me are pretty well answer that. But there is another issue in the case that they'll have to grapple with. But and of course, one of the cases that helped confine the Commerce Clause, you might say, was the Violence Against Women Act case that Bill Rehnquist wrote on that, which is an issue that's coming back now.
On a finding that there was not enough commerce connection, but on the pending case, you have a view as to how that ought to come out.
Well, I haven't read the briefs, and I really wouldn't want to express an opinion on the bottom line of the case or the Anti-Injunction Act issue or any of those issues unless I have a chance to read the briefs, but I will be interested in seeing what they decide. And
you've written a couple pieces for the New York Review of Books, which is certainly an aspiration of many writers. You had one recently, a review of that interesting Delaware case the book about the Delaware capital
the
case.
rape case by Irving Morris. Yeah. That one reason I was interested in writing that review is because Irving's an old friend, and he had actually, and I didn't get the message, asked me to write an introduction to the book, but I didn't realize it's a long story that really doesn't matter, but it gave me a chance to talk about a case in which Irving represented me in a suit arising out of my service as the director of a corporation that had no assets except tax loss to sell. And when after we arranged to sell the case to sell the corporation to a very profitable concern, they brought suit to cancel the stock options that the directors had granted to themselves. They said there's a breach of trust there. And that was the only compensation that the directors had to work this out, and they succeeded in their venture. And so I thought that I was one of those who thought it was an appropriate method of compensation. And they brought litigation against us, and Irving Morris represented me in that case. So he was my lawyer. And one of the reasons I had an interest in writing a review of his book was an incident that happened during the trial of the case that I got a chance to tell in the review, which was the fact that the lawyer for the other side represented to the judge that I had been untruthful in my testimony in the case. And Irving said, well, you got to put a witness on to say that. And so they called their witness to the stand. And as he got on the stand, he was going to contradict my testimony, and I was quite confident that my memory was accurate. But when he got on the stand to testify, he had a heart attack and died in open court. And that was a rather dramatic...
Don't mess with John Stevens.
And so it gave me a chance to tell that story.
It's a pretty good story. So during the 30 years or so that you and I were both in the same venue, we actually didn't talk very often at all, but the few times we did, I always came away with some really interesting little window into your thinking, and I'll just recount one as a segue to another subject. It was the case of Scott against Harris. If you remember that case, it was a due process case that had come up on summary judgment about whether the police in a chase who forced a young driver off the road on the ground that he was driving so dangerously that the public was endangered, forced him off the road. The car went down an embankment. He was rendered a quadriplegic, and the question was whether his due process rights were violated by unreasonable police behavior. And the court posted the video of the chase on the website when the case came down, and by a vote of 8-1, the court found that the chase was reasonable, and you were the one. So I remember running into you at the court, and I said, you know, Justice Stevens, I think you were the only one who got it right in Scott against Harris. And you said to me, well, I'm the only one who knows how to drive.
I don't remember that, but I might well have said it. Because I learned to drive when, two-lane roads were common. You had to learn to pass in fast traffic and so forth and so on. But the interesting feature of that case, Linda, one of the interesting features was that when you looked at the video was not really, it was in the record, so it was proper to look at it. But when you look at it by yourself in your chambers, you don't get the help you would get from a lawyer if you're in open court commenting on it or asking questions of witnesses about what went on. And the thing that struck me about the video was that they saw these cars when the lights would come on, and then the video was taken from the police car chasing the speeding motorist. And they had a camera in the police car, and the camera would see these lights zooming at you, very frightening. They get off the road just in time. It looked like it really was a terribly dangerous thing. The only thing that you didn't get if you just watched the video was, unless you listened very, very carefully, was that there were sirens on the police cars that were changing, so that the motorists had notice in advance. It was like a fire engine or something coming in, so they pulled off the road. And looking at it at high speed, it looked terribly dangerous. But you got a very different impression if you realized at the time that they had adequate warning, just like any other time when an ambulance or a fire truck is going with sirens, people get out of the way, and there's not that much risk. And so the videos, without the explanation of counsel or witnesses, gave a very misleading impression. And you just had to, they were not shown in open court. We were given copies to look at in change rooms. And I thought that my colleagues did not have the benefit. It took me a while to figure out what was going on with my law clerk. And I think they came to an inaccurate factual determination in a case where appellate judges should rely on trial judges and the lower courts to sort out the facts. And in the case, both the trial judge and the members of the Court of Appeals had held there was a jury question that should be resolved, and no summary judgment should be granted. I felt it was an example of judges, appellate judges, not really participate in the limited way that they should in the appellate court. And I was really, as you can tell, I was bothered by the result. I think it was an incorrect decision. And when they show the video to the public, and as they did, they also won't get the answer, because that won't be entirely clear to them. It's not something that should be, a piece of evidence should not be analyzed all by itself by judges without the assistance of counsel and witnesses and the like. And I just felt that they did not discharge their duty properly, and they're more conservative drivers than I am, and thought it was much more dangerous than I did, and that showed up in the case.
Yeah, you flew your own plane until not too long ago, as I recall.
Yes, that's right. Well, it's been several years.
But, I mean, obviously, the case obviously bothered you, and what you just said about it is so obviously reasonable. It's just kind of surprising that nobody in the conference could be persuaded by the force of what you just said here.
Well, if I were to tell you about all my failed efforts to persuade my colleagues at conference, we'll be here a long time.
Well, that's the subject I wanted to move to. So you published 720 dissenting opinions during your tenure, which is the most of any justice in history. Justice Douglas comes in second with 486. So you were way ahead. There's not my counts of the recently published
it's a little embarrassing.
articles. So obviously you're a believer in the utility of a dissenting opinion. And a passage in your book that grabbed my attention was your comment on the unanimity in Brown against Board, which in Brown against Board of Education, which of course everybody holds up as, look how wonderful Chief Justice Warren managed to extract a unanimous opinion in this landmark case. And what you say in the book is that the unanimity in Brown came at a price, and the price was the compromise of not having dealt immediately with the remedial question, and of the all-deliberate speed, which left everything just kind of out there happening slowly. So I want to give you a chance to talk about why a judge publishes a dissent, why you publish so many dissents.
Well, in that case, I think probably they all did end up persuaded that it was the correct decision. But I don't think that the fact that it was unanimous was really all that important. And I do think that the sending it back for further consideration and so forth actually lent strength to the people who did not want to comply. And I've actually, I was just expressing my opinion in the time I wrote the book. But since then, I've read a biography of Judge Tuttle, written by one of his former law clerks, who's a teacher at the University of Georgia Law School, I think. And I commend it to everybody in the room to learn about what kind of a judge Elbert Tuttle was. He was really a surprisingly fine judge. But one of the things that comes out in that book, that 8 or 9 years after Brown was decided, there was still the University of Mississippi, the University of Georgia, and the University of Alabama were still all white schools. And 9 years went by. And I really think that if the court had dealt with the decision ordering immediate relief in the particular cases before the court, as had been done in the Delaware case, that there would have been a very different and much more prompt solution to that very difficult period in our history.
Even with a couple dissenting opinions.
Absolutely. The dissenting opinions would really merely make it clear that there were 1 or 2 justices on the court who agreed with the thinking that was prevalent in a large part of the country. There were a lot of very fine judges. Now, I don't think they were fine on this issue, but there were respected judges who took the dissenting position in resisting implementation later on. And that comes out in some of the writing in the book by Judge Tuttle. And I don't think the fact that it had been might have been non-unanimous, I don't think it would have been non-unanimous, but the fact that there might have been a dissent would have been all that harmful.
Of course, you're the author, as Dean Post alluded to, of some passionate and proud dissenting opinions of which you should be proud, and Heller and Citizens United, Bush against Gore. I'll mention Texas against Johnson, a dissenting opinion that maybe not everybody expected, the flag burning case, right? There are 2 that you single out in the book that I think people might not necessarily off the top of their heads think of when they think of your jurisprudence. One was your separate opinion in Karcher against Daggett, the redistricting case, in which you think the court took a serious wrong turn. Why don't I stop there and let you talk a little bit about where the promise of Baker against Carr, in your view, got distorted?
Well, it's interesting you mentioned Karcher against Daggett. That's a case, for those who are not familiar with the case, but basically the court held that the 1 person, 1 vote requirement was very, very strict, and very, very minor deviations were sufficient to violate the rule because the state of New Jersey had been unable to justify them. And that was the holding in Justice Brennan's opinion. And I wrote a separate opinion saying that I thought that the gerrymander was violated the Equal Protection Clause, and that we attached a map of the different districts and showed how gross the gerrymandering was. And just within the last 2 or 3 days, I was talking to Dina Mishra, who's here, my law clerk, and we talked about that case. And I mentioned to her, I think this is right, isn't it, Dina, that I have thought maybe I should have identified that as a case in which I did make a mistake. And my mistake, I think, was in joining Brennan's opinion and not writing merely my separate opinion, because then my separate opinion would have been controlling, because it was a 5-4 case, and I went along with the numerical decision, which I really didn't think was all that persuasive, because if you require such complete equality of numbers, that the numbers of people in the district will change between the time of the sentence and the time of election anyway, so it's an impossible goal. And we're talking about that case which you bring up, and I was thinking, well, maybe that was a mistake. I should not have joined the majority.
Mm-hmm. And the other dissenting, excuse me, the other dissenting opinion that certainly comes through in the book that you felt very strongly about was Seminole Tribe.
Yes.
Where you feel the court made a drastic wrong turn.
Yes, in a way, I've thought of the book as a petition for rehearing in Seminole Tribe. Because I guess I did spend more time on that case than I should, but I still find it mind-boggling that in the Chisholm case and the 11th Amendment and so forth, that in essence the country decided that the common law rule of sovereign immunity had not been repudiated by the Constitution. It survived. And it had not, the fact that it had not been made unconstitutional doesn't seem to be the equivalent to saying it has been permanently enshrined in the Constitution as part of the design of the Republic or something like that. Rejecting a common law rule should not be translated into the formation of a constitutional rule. I've tried to make that point unsuccessfully over and over again.
And you write that you think Chief Justice Rehnquist's opinion, majority opinion in the Seminole Tribe, is going to go down as the most important opinion with his name attached to it.
I think, well, perhaps that, or the case reaffirming Miranda, upholding is a very important opinion of his. But on the one of the opinions in that sequence invalidated a congressional statute that made states subject to liability in patent infringement suits, and which is totally inconsistent with the notion of protecting the dignity of the sovereign, because the back, as Judge Wood pointed out in a recent opinion in the Seventh Circuit, the doctrine should not extend to the commercial acts of sovereigns, because that would not have been part of sovereign immunity in the common law or the early days, and to extend it beyond its source is totally unjustified.
So you write in talking about your years as the senior associate justice with the power to assign the majority opinion when you and not the Chief Justice were in the majority. You mention your assignment to Sandra O'Connor in the Grutter case, and you say that Grutter, we're pleased with the outcome and happy with Grutter, and that it will, quote, pass the test of time with flying colors.
Yeah.
Okay, so here we were.
Well, people who heard the argument today may not agree. You know?
Here we are with our moot court this afternoon, and so do you think Grutter passed the test of history with flying colors?
Yes, I do. I think the decision was correct. I think it made the and of course in the argument today they pointed out the fact that the experience in the military, it was a very, very big part of that decision, and so I think it is. Yes, I think the opinion will pass the test of time.
You tell the story of going to Carter Phillips after you left the court to ask him where the idea for that famous military brief came from, and the answer, in case people don't know, was it came from Gerald Ford.
That's right.
Right? Is there any deus ex machina today that you think might save Grutter from the current court?
I don't know.
Okay.
I don't know.
Your own encounter with affirmative action over your long career on the court, starting, I guess, back in the Full of Love case, or starting with Bakke and through Full of Love and on to Adirond, and the cases since the Croson and the cases since then. At least it seems, at least from the outside, that you came to see the issues in a different light over time.
You know, the case that I think of as really most significant in my own development and my own thinking on affirmative action was the Wygant case, which was discussed at some length in the moot court this afternoon, and none of the participants in the debate really talked about the facts of the particular case. It was not a case involving preference for students. The question in the case was whether a contract which had been given to an African American in order to retain her services in the event of a cut down in the size of the faculty would be enforceable, notwithstanding the fact that it only benefited the African American teacher. And I remember when the case came up, I thought that was really significant because they were looking at the future benefit of having an African American on the faculty and the educational benefits that the students would derive from keeping that faculty member for the future. Whereas if they let her go, they would return to an all-white faculty. And it seemed to me that the planning ahead, which protected her job, was thinking about the future educational benefits of that particular rule. And I remember after reading the briefs and preparation for the case, I had a meeting with Justice Powell in his chambers to talk about something else. I don't remember exactly what it was, but I remember going down and talking to him about something. And just as I was leaving, I remember saying to Lewis, well, we finally got an affirmative action case that's going to be easy. I think it's a clear case, and he said, you're absolutely right. It's great to get an easy case in affirmative action. And we left, and that's the way each of us thought it was easy for different reasons. And we found out afterward. But I thought that case was so significant because it focused on the future of the program and its impact on people who would be affected, rather than as a payment for justification for harms that have been done in the past. And I think that makes a world of difference when you look at these issues, as to if you look at it in a forward-looking capacity rather than a backward capacity, you appraise it in a different way.
And so the benefit not only to the individual involved, but to the wider community.
Correct, correct.
So,
there was a public interest in having a faculty in the high school in Jackson, Michigan, that was not an all-white faculty.
well, speaking of the moot court, so you seem to still be really bothered by Chief Justice Roberts' little saying about how to end discrimination, and that seems to still rankle.
Well, I think it's a very persuasive statement. By a lot of people are very much persuaded by it, and I was surprised that people arguing in moot court wouldn't have picked it up.
Mm-hmm. Yeah. And of course, Justice.
By the way, they did a wonderful job in the moot court.
So you had your own chance once at oral argument before the Supreme Court.
Pardon me?
You had your own chance once at oral argument before the Supreme Court, which you write, you found a rather surprising experience since you, as a law clerk, you thought you knew the court pretty well.
Well, the surprising thing is, as you know from the book, is when you and I've verified this with John Roberts and with Ruth Ginsburg and others too. The first time you get up to to address the court, you people are miles away. The bench is about half the distance between us and the front row here, and it really is a frightening experience to have that sudden feeling. Well, by golly, these guys are right within arm's reach, and I remember that very vividly.
When you mentioned just now visiting Lewis Powell in his chambers, am I right that one reason that kind of stands out in your mind, aside from the fact that the Wygant case came up in conversation, is that, at least it's my impression, justices don't tend to just kind of bop into one another's chambers, right?
That's true. Of course, I don't know always about my colleagues, but I very rarely would visit in another justice's chamber. They would very rarely come to my chamber, but it happens. I mean, I'd been in Justice Brennan's chambers to talk about cases, and others had come to talk to me, but it did not really happen very, very often. We did generally communicate in writing with memos about cases, and then we'd also talk on the phone a good deal in particular case, but it's not something that's routine.
So it kind of stands out in your memory as not an everyday thing.
Although I must say I did have conversations with Justice Powell more than most members of the court. Both he would stop in and see me, and I would talk to him. We had certain common history that gave us a common interest in a number of things.
In the history of actually having been practicing lawyers, or?
Well, both practicing lawyers and both our military experience had a certain similarity to it. He was involved in communicating to the operating forces results of our intelligence that obtained from decryption. And it was very important not to let them know where that information came from, because they might be captured, or it might.
He was decorated for that, as I recall.
Yeah,
right. I want to talk about just a few more areas, and then we've got some written questions from the audience. One is City of Burney.
Is what?
City of Burney, the
right.
Section 5, 14th Amendment case that overturned the Religious Freedom Restoration Act as applied to the states. You voted with the majority in City of Burney, and I just wondered whether, in the passage of time, you had occasion to wonder whether that case became what you thought it was.
It certainly it became more than I realized at the time, but I still think it was a correct decision. I think that Congress was trying to act like trying to amend the Constitution when it enacted that statute.
Right. How about Chevron? Most cited case in history, as Dean Post said. Did you think you were launching a revolution?
No, I really didn't, and I'm not an expert on everything that's happened to Chevron since, but I thought it was really pretty well settled law that we should defer to the agency in a case like that, and of course that was not unanimous when it was discussed at conference. Warren Burger passed, and Bill Brennan voted the other way. And Byron had to assign the case, and he asked me if I'd be willing to take it on. And I spent most of my writing on the case was a very careful study of the facts and the history. The part of the opinion that's most frequently quoted is a very 2 or 3 pages in the middle, and they're about 30 or 40 pages before and after that I wrote out in yellow pad.
You quote, in the book, you quote somebody, I'm trying to remember who it is, who said, "An author is seldom the best judge of how readers will react to his work."
Right, I have quoted that. That's a quote from Abe Lincoln.
Okay.
I forget just when he said it, but he said what I say here will neither be long remembered or well remembered. Something anyway.
Right, and that's you quote that. So that would probably apply to Chevron. It would.
Well, I don't know. It's not in the same ballpark.
Maybe apply to your opinion in the Paula Jones case. Maybe apply to Kelo, the takings case, which you thought was quite an ordinary application of takings law and launched a firestorm of controversy.
That's probably the most unpopular opinion that anybody has written during my term, but it was dead right. It was absolutely right, and it's interesting because it's criticized for not being faithful to the text of the Constitution, whereas the text of the Constitution merely requires that when there's a taking, the person whose property has been taken be compensated. A literal reading of the text is merely a requirement that there be compensation paid. It doesn't place any limit on the purpose for which compensation taking can be made. And Dean Traynor has studied that at some length, and that was the purpose. It was to prevent further uncompensated takings. It wasn't, and of course, if you read the earlier cases, they're much farther in their language than even Kelo did. But Kelo was unpopular because the project, well, there are all sorts of reasons why it was unpopular. The project was not well thought out. The big drug company abandoned the city after it started, so the thing was not a success. And of course, it was a private home and a very sympathetic person who lost her property.
Right. I'll ask you about one more topic, and then we'll turn to these, to not all these questions, a few of these questions. As you've written, and as we know, when you were nominated to the court at the end of 1974, in the shadow of Roe against Wade, you're the first person nominated to the court after the court decided Roe. You didn't get a single question about Roe in your confirmation hearing, and I gather, hadn't yourself had much occasion even to think about the issue. So just reflecting back to that simple age when abortion was not a highly politicized topic, I just wanted to give you a chance to reflect on that.
Well, one of the things that reminded me of that situation was the fact that when Justice Thomas went through his confirmation hearings, he was asked about it. And wasn't this the subject of discussion here at Yale Law School when he was a student? And he said, no, it really wasn't. And people they thought he was not being truthful in his testimony. And I felt that was terribly unfair to him, because it was about the same time that I went through the hearings, and I wasn't asked questions about it in a context in which you would have expected it if it was a burning issue. And I just thought it was interesting that it later became, of course, there's a lot of mail was sent to Harry, there's no doubt about that. But as to whether it was a prevalent topic, I really don't think it was at the time. At least that's my memory.
And so how did it happen that it, in your view, became such a...
Of course, all sorts of, some of the same reasons Aquila was so unpopular. There are groups out there that don't like some of our decisions, and they explain publicly what their views are and stir up positions that later have political significance. And
when you came on the court, you had no particular view about Roe one way or the other. I gather you hadn't had much occasion to think about it, but by the end of your tenure, you were one of the most stalwart, significant defenders of Roe.
I think, well, I was one of them, yes.
Right. I mean, did that reflect your view, your stare decisis view, or?
Well, I think I make this point in the book. I never thought that it was the right was best explained as a right of privacy following from Justice Douglas's opinion in
Griswold.
In Griswold. I thought that was not a very persuasive opinion, talking about penumbras and all. I thought and still think that Potter Stewart wrote a very succinct statement that this is a terribly important liberty interest, and if you focus on the liberty interest and the importance of the decision to the person who has to make the decision, it seems to me you get a better appraisal of why it is of constitutional significance than when you talk about it as sort of a penumbra in privacy and all that.
Yeah, I mean, I guess people were busy running from Lochner and running from substantive due process, which in your view would have been a
That's right.
stronger
right.
basis. Let me turn. We have some baseball questions here. I'll set those aside just for now.
Talking about substantive due process, the Kelo decision, was a substantive due process decision. Really, the case that this old CB&Q case, which is cited, and I made the mistake in a footnote in Kelo of citing that as having incorporated the Fifth Amendment. Well, that case doesn't even cite the Fifth Amendment. It's a case which held that the 14th Amendment has substantive significance as well as procedural, and that as an old common law rule, uncompensated takings, there must be compensation on a taking, and that's what the case held. It was a substantive due process case.
Well, maybe not the last one ever to come down, but if people are afraid of that kind of response, let me just find some. Right, and people are having trouble hearing. So
I'm sorry.
Okay, right. Okay, since you left the court, what decision by the court has been?
I'm sorry?
Since you left the court, Question, since you left the court, what decision has been the most disappointing and, on the other hand, the most heartening?
Well, I really think the most disappointing case has been the case in which the Louisiana prosecutor concealed evidence that resulted in a man having to stay on death row.
Right, the Connick case. Right.
I really think that was really a bad case in two levels. One, I think it incorrectly concluded that there was no liability under existing law for failure to train the members of the staff for the very flagrant violations of the duty to disclose exculpatory evidence. But even beyond that case illustrates how wrong the court was in Tuttle against Oklahoma City and not applying respondeat superior as a basis for liability against public officials, because the Tuttle against Oklahoma City and the earlier case that Justice Monell relied on very incorrect analysis of legislative history and reached a flagrantly improper result. And if the court or Congress simply applied the respondeat superior rule to a prosecutor's office, they wouldn't have to engage in lengthy trials about whether training was adequate or all this sort of stuff. It would simply provide a rule that would lead to careful attention to the constitutional requirements. So that's one that is really bothered me.
Right. Do you agree that the best way to end discrimination on the basis of race is to stop discriminating on the basis of race?
Well, there are two parts to the question. You have to ask what is discrimination on the basis of, it's interesting to go back to the argument today for a minute. They're talking about the injury to two white students who did not qualify because they have a larger pool available for other purposes, one of which was the affirmative action. But if they had a larger pool available, say people wanted to study Oriental art or something, they reserved 200 places in the class for people who wanted to specialize, there would have been the same harm to the plaintiffs as there was there. So they were not discriminated against on account of their own race. There was some other people who were benefited by members of a different race, and the impact on the people who were hurt is exactly the same as if the same number of spaces had been reserved for a non-racial purpose. So is it discrimination on the basis of race,
right,
or wasn't it?
Right. So that's the antecedent question that you have to answer before you get into that little slogan, I guess. Do you still hold to your opinion in Texas against Johnson, the flag burning case?
Well, I think it was incorrectly decided. I would not, obviously, I wouldn't overrule it now. I think there are two or three interesting things about that case. One is that nobody burns flags anymore, so it obviously isn't a vital method of expression. And the other thing that troubled me about the case was that the rationale, if you read the opinion closely, was that it was viewpoint discrimination. It wasn't the fact that the people who were demonstrating and were opposing the Reagan administration's policies didn't have an adequate opportunity to explain why Reagan was all wrong. But the message that the flag burning carried, according to the majority, was that we don't like flags, or we don't like statutes that prohibit flag burning. It was a point of view about flag burning, which was, and that if you follow that reasoning, almost any kind of expressive conduct would be viewpoint related, because if you engage, say you don't like nude
dancing
or parading in the nude. It's against the law, and it should be protected because you're expressing a viewpoint that parading in the nude is okay. And so that it's a very broad rationale that the court used in the case, which I really don't think is correct. Mm-hmm. So I remain persuaded that the case was incorrectly decided. Now, I think you can make an excellent argument, it may well be true, that having the symbolic value of saying this is a kind of free country in which any citizen wants to burn the flag shows how free we're. There's great value in that. There's no doubt about that. But as protecting an important means of expression, the case is a zero, because nobody ever burns flags.
Yeah, once it became constitutional, it was no more fun.
That's right.
Anymore. You game for a couple more questions?
Sure.
Okay. After the healthcare, we'll read this together. After the healthcare arguments, many court watchers lamented the court's tone, separate and distinct from the substance of the arguments. How has the tone of the court changed, and are you troubled by it? Did you listen to the arguments, or did you read the transcript?
No, I haven't. I've read excerpts. Well, it's always been a problem. I mean, there are some arguments the tone is a little more adversarial than it might be in others. I really believe that the oral argument process works well on the whole, and I would not want to criticize any member of the court for his participation in the dialogue, because the dialogue is very helpful to the decision that's ultimately made.
How about criticizing anybody for not participating?
Well, I would never criticize Clarence Thomas. He believes, and I think correctly, that he wants to hear what other people have to say, and he's always, you may not know this because he doesn't ask questions, but he is always thoroughly prepared before argument. He knows everything in the briefs. He's thought about it a lot. He wants to hear what's said, and he thinks he gets more out of listening, and there's a lot to be said for his point of view.
Do you believe the current rule of optional self-recusal should be changed? You know, there's all this debate now about ethics and what should be binding on the court.
No, and I also am very much opposed to the notion that justices should be compelled to explain why they recuse themselves. Because there was a case that I recused myself from when I was a Court of Appeals judge, in which the reason for my recusal was I had some adverse opinion about one of the parties to the case. And I thought if I had been compelled to explain why I recused myself, it would have been very prejudicial to one of the litigants. And I think there are cases in which a disclosure rule requiring justices to explain their reason for recusal would not be in the best interest of the court or of the litigants.
Okay, maybe we'll make this the last question. Do you think the court's activity should be more transparent? Or I guess to broaden that a little, do you think there's a way in which the court could change its behavior to make the public at large have a deeper understanding of the court and its processes and what it does?
Well, of course, the people who say they should, or this is a question designed at favoring televising proceedings, but I would not do anything that would impair the ability of the court to conduct their oral arguments in the way they think is most effective. And televising would benefit the court and the public from learning how well prepared the justices are and how they do have intelligent questions to ask. And so that would be a plus. But I think it is more important that the court operate effectively. And I think that the oral argument on the whole is a constructive part of the process.
Well, I think with that, we've had a good chat, and I thank you.
Well, thank you, Linda.
Very much.